important clauses to consider when creating your Islamic will. Okay? So, I will divide my talk into 3 parts. I'll try to finish at 8 o'clock because my train is half past 9. It's back to us, so I would like to go ASAP. So first we got to understand the concept of a will compared to wasiyah. It's a confusion in our community. I want to highlight that. Then, what are the legal requirements? Because we're living in UK. You've got to follow the law of the land as well, if you have a will. What the law of the UK requires from you when you draft a will. And finally, I'm going to hint at some important clauses that you can consider, provisions in your will as a Muslim. So, part 1, the difference between a will and a wasiyah. What is the will? Lawyers don't answer. What is a will? Any idea? What is a will? No, inheritance.
Will is what your wishes are. Essentially, when you pass away, what you want to do with your wealth or whatever you leave behind.
One important word is missing there, according to the Wills Act. It should be written. There are some exceptions for sailors and soldiers. It is a written expression, that is what you want. A written expression of the testator, that is the person who has the will, the man. If it's a woman, you call it testatrix. It is the written expression of a testator or testatrix regarding how he or she wishes his estate, that is, whatever he has, his house, his gold, his cash, or whatever, be distributed after his or her death. After his or her death. So that document is so important. If somebody plays with it, it's a criminal offense under UK law. You can end up in jail with that. It's not an ordinary document. Because we know cases where the children, the will is not in the favor, they destroy the will. There are cases like this. So we want to be very careful when it comes to a will. So a will is a written expression, what you want, your wish, what to do with your estate after your death. So only after your death it will have an implication. Right? So why do we need an Islamic will? Wasiyah is not will. We'll come to that later on. Why do we need Islamic will? Inheritance tax. That is, Islamic or non-Islamic, you will have to pay. That's it. Even if you got a will, under certain circumstances, you still have to pay. But the will can mitigate it, yes.
No, it's important to have Islamic will because otherwise the land of the law will apply.
Yes, the law of the land will apply. And I'm going to give you 2 examples for you to think how serious it is from a Sharia point of view. Now, reasons for having a will, number 1, the statistics. The tendency in UK, according to the ONS, that is Office of National Statistics, you can go online and check it, 70% plus minus of the British in general, not Muslim, in general in this country, do not have a will. And when you look at the case laws in the High Court, it has tripled compared to maybe 10 years ago. More and more people are going to court and fight when we are not clear what to do with our estate after our death. So the statistics are there to prove either our family will fight or people don't even have it. Okay. Number 2, once you have a will, you can protect your heirs. The government, the probate officer will say, okay, that is right, you go. You are protecting them. Number 3, for example, we know many cases when there is no will, the children take everything and the mother is left like this. There are so many cases come to me. Number 3, if we don't have a will, and this is very, very, very serious now, there are approximately 35 verses in Surah An-Nisa dealing with the law of inheritance. The probability is, if you don't take the necessary precaution with it, you will be violating those verses of the Quran. And Allah says in the Quran, after He has given all the directives, تِلْكَ حُدُودُ اللَّهِ. These are the boundaries set by Allah. We are not supposed to go outside those boundaries. So a will empowers us to implement those ahkam of Allah. It facilitates the winding up of the state by an appointed executor. So when you die, you have a will, your lawyer will send it to the probate office. The probate office will say, okay, there is an executor. The executor is the person who will collate all your asset and make sure it's being distributed, etc. When you do not appoint one, it will delay the distribution of your estate. Because now you got to apply to the court to appoint one, and that will take time. So instead of 3 months, maybe you wait 12 months, maybe more. That is now causing problems in the family. Why? One of the problems you're going to have is when you die, your assets are frozen. Listen to me properly. Your assets are frozen. You can't touch it. The executor will have to collate it. If you do not make provision for your wife, for example, she might not. There are some provisions in law. You're complicating their life to access the money you got in the bank. So it will facilitate all those things. So even your asset is frozen, you can make some provision for your wife to get some money. For example, during her iddat, for example, she will need money, right? Number 5, you can use your will for tax exemption. The way you plan, what I said earlier on, estate tax planning. This is a very specialized area. I'm not to talk about it today. Very important, if you have minors, many people don't realize, listen to me properly, brothers, the upper guardian of your children, you are not the upper guardian of your children. It is a judge of the High Court, not you. Under the law of UK, you are not the upper guardian of your child. It's the High Court. So if you die, you got minors. You can appoint through your will. There are academic papers on that. There's no time to go through those details. You can appoint who can be the guardian of your children. Why this is important? Under Sharia, if the mother dies, the nanny looks after the baby. If the nanny is not here, the sister of the wife, it is a matriarchal line, the female who look after that. It's quite well entrenched in fiqh. Okay? If you don't do that, the court will look at the best interest of the child, which is not exactly what Sharia is asking. Right? So you got an opportunity through your will, if you got minors, to mention, if I die, so and so, my sister or my mother or whatever will look after my child. That you can put in a will as well. An opportunity to make a wasiyah. Wasiyah means a bequest under English law. A bequest. That is, you got to differentiate between inheritance. Inheritance is what the law says you will get. Bequest is you decide. Sharia gives you up to 1/3 of the value of the estate to give to whoever you wish, provided that person is not an existing heir. You cannot make wasiyat for your wife, for your son, for your daughter, for your spouse. You can't do that because they're already heirs. But suppose you had an auntie who was looking after you when you were small. You want to make a small gift for her, provision for her in her old age. That is where this 1/3 comes in. Or you want to set up an orphanage, or you want to give money to this masjid. That 1/3, you can use it to do those things. Or you never perform Hajj. There is outstanding zakat. This is where this 1/3 is being used. If you don't have a will, this cannot be implemented. This is why it's important to have a will. Next one is an opportunity to make a sadaqatul jariyah. That is, after you die, your book of deeds are closed. But Sharia allows you, through the wasiyah, even you died, your book doesn't close. For example, you set up an orphanage. Example, you set up a well in a desert country. You set up a Darul Uloom. You sponsor a Hafizul Quran. All these things are sadaqatul jariyah. Through your will, you can set up all those things. Even you die, your book of deeds continue. So don't forget to have your will. Not one. Pay your debt. Many times people don't care about their debt. Brothers, the hadith of Rasulullah is very serious about debt. If you have a debt, you don't make the necessary precaution to pay for it. You don't want to pay it. You're careless with it. In the qabr, that debt will rotate around the head. And you don't know when it's Qiyamah. So if you're going to stay 1,000 years in your qabr, 2,000 years, 5,000 years in your qabr, and your debt is turning around your head, what's going to happen? Rasulullah sallallahu alayhi wa sallam, there was a Sahabi. Rasul went in front to perform Salatul Janazah. And he said he got a debt. Somebody said yes. Rasul said, I'm not going to perform Salatul Janazah. Somebody had to pay that debt. Then one Sahabi took responsibility to pay for that debt. So don't underestimate. Many of us are having credit card. I'm not going to the halal and haram of credit card here. That's another story altogether. I'm not to go into those details, right? People think I've got 55 days to pay my credit card. Thereafter, if I don't pay, then that's under 20, 30%, whatever the rate of interest is. It's a debt. You got a mortgage. It's a debt. If you're a businessman, you have creditors, it's a debt. All these you got to prepare, make sure that those debts are met, and do not expect your wife to know who you owe. Do not expect your children to know. So what you do that, you have to a codicil. You call it a codicil. It's like an annex you put with your will. I so and so I owe. And you got to revise it every year. Right? It's very serious. Next one is avoid unnecessary litigation in courts. If you don't have a will, probability is, if you haven't given proper tarbiyat to the children, it will end up in court. You got lawyers sitting there, he knows what I'm talking. I'm a lawyer, I know what I'm talking, and there are other lawyers. If you don't have a will, I would say 80%, your children will fight if the tarbiyat has not been made. So when you have a will, it's done, it's clear cut there, provided the will satisfies the law of UK, right? So these are the reasons why we need to have a will. So if there is no will, what happens? If there is no will, then the law of UK will apply. We call that the rule of intestacy. We call it the rule of intestacy. So when a person dies, right, without leaving a will, the rule of intestacy means that the law of UK will apply. You cannot do whatever you want with your estate after your death, right? So even if someone makes a will, listen to me properly, even you left a will, and if this will is legally wrong, the court will reject it, then too the law of intestacy will apply, right? So we got to be very careful. So what is the implication of intestacy? That is when you don't have a will. English law, so because you have no will now, Sharia will have no place into that. So under English law, only the spouses who are court married, listen to me properly, I know what I'm saying. You have, some people are making only nikah. Nikah is not recognized in this country. There was a case, appellate division, in 2018, Khan versus Akhtar. The High Court says, nikah is not even a marriage. Understand what I'm saying? So, up to you, you want to be court married, not court married, that's something else. But, under English law, there is a concept called freedom of testation. That is, you are free to give to whoever you want your estate, provided you don't have certain duty towards others. I'll come to that later. So make sure that you have a will. If not, the law of intestacy will apply. What does that mean? I'll give you an example. Sorry, before that, you can see that cohabitees, that is, you have no nikah, they will treat you as cohabitees, not like husband and wife. Cohabitees, if you are not court married. Or no, in a civil partnership, can't inherit under the rules of intestacy. Your wife will not be inheriting if you do not have a will. She's not recognized as your wife under English law. So mere nikah is not recognized under English law. I give you the case law, it is available on Google. Please go and read to confirm yourself that what I'm saying is the right thing. Next, please. Let me give an example. Mr. Junaid is court married to Miss Kulsum in 1890. He's married, court married. Then he made a nikah with Miss Zulekha, and under Pakistani law, he went to Pakistan, he got married, and under Pakistan, nikah is recognized as a civil marriage, just like here. Then, in the year 2000, he got Josh again, he wanted to get married again. He married Miss Fatima according to Islamic law only in UK. So, married Kulsum, court married, Zulekha, Pakistani law is recognized in Pakistan. Number 3, Miss Fatima, only nikah. Last week he had a heart attack. He cannot handle 3 wives. He got a heart attack. Suddenly he passed away without a will. Tell me who will get what under English law now? Think of it. Kulsum will get it. And what about Zulekha, the civil marriage? It is recognized in Pakistan.
If he has any wealth in Pakistan, he will get it, otherwise not.
Under English law, I gave a legal opinion on that recently. If you have bigamy, it falls under the law of felony, it's 7 years jail. 7 years. So those who got wife in Pakistan or whatever, civil marriage, be careful. Right? So, that is the law of UK. If it is only nikah, no problem. If it is a court marriage, it's a problem. Ajib call, but this is a law. Right? You can have mistress, no problem. Na'udhu billah min dhalik. But the moment it's a court marriage, now we're sitting with problem. Right? Okay? So you are right. Zulekha will not, under English law, it will be problematic. If he brings it to court, it will fall under, I think this act is 1357, something like this. It's an old act of parliament that governs this type of thing. All right. Okay, is that okay? Do you see, if you don't have a will, what happened? Islamically, how it should be, if it was Islam? 1/8 should be divided among the 3 wives. So at least it's guaranteed. Okay. Now let's continue. If there are surviving children.
Sorry, the question is, so if there is a will, and that is according to Islam, does English law would allow it to be a legal will to be executed?
Yes, there is a concept called, it must not be against public policy, contra bona mores. It must not be.
No, in this case, I mean, if it is to be 1/8 to go to
Yes,
each of
under
the
freedom of
wives.
testation.
Okay.
Yes,
But
usually
then,
under freedom
in a
of
way, are you not
testation, the
declaring
court
that
will
you had
uphold
three
it.
wives?
Sorry?
So in a way, are you not declaring, are you not disclosing the fact that you had 3 wives?
No, that's what I'm saying. The moment you're going to declare you got 3 wives, you're going to have a problem.
Exactly that. So,
Yeah.
so
They will tell you it's against the public no, public interest. Yeah. You're shooting yourself in the foot.
Exactly.
So you got to find other ways.
Right.
So Islamically, yes. Law of England, no. Kulsum is the one who is court married, the one recognized. If you bring the Pakistani one here, I'm afraid it will fall under felony, and you can end up in jail with that. Yeah. All right. Okay. The other one is only nikah, it's not recognized, so there is no will. She can't go to court. She's not recognized. Right? Of course, you can go and discuss the whole debate about common law wife and so on. I don't want to go into detail. As a general rule, it's no. So interesting in case of intestines, if there are surviving children, grandchildren or great-grandchildren of the person who died, and the state value, listen to me properly, is more than 270,000, right? 270,000, the spouse will inherit. What she will get? The spouse, again, the wife who will get, not your children. The wife comes first, your spouse comes first, or your husband, or the personal property belongings of the person who has died. If it is less than 270, she gets everything, or he gets everything. If there is anything left, you will give 270,000, first 270,000, and what is remaining she gets, or he gets half of it. I repeat, if a person dies, if it is 270,000, the worth of the estate, the spouse gets it. If it is above 270, he will take or she will take 270,000. What is left, half of it will go to that spouse. Do you understand?
Yeah.
That is the law if there is no will.
Sorry, the other half then goes to the state.
No, we come to that. Here's an example. Farooq was in a civil marriage with Zainab. Brother Farooq, but married to Zainab. How there no Farooq here, right? They adopted a daughter called Halima. Okay. Farooq had a brother called Rashid. Farooq died intestate. His estate was worth 450,000. So definitely you can see here, it's above the 270,000. Determine who receives what amount under English law of intestacy. So he didn't leave a will. He had his wife, Zainab, he's married, court married with her, a brother and an adopted daughter. Who gets what? Remember the rule of 270,000 and the half. Very easy. Think about it. Okay. Half. The remaining half, what happens? To who it goes? This is a question that you ask. It goes to Halima, the adopted son under English law. All right? Is that okay? She got the 270,000. What is remaining? Half. She gets half of it, 90,000. The remaining 90,000 goes to Halima, the adopted daughter. Under English law, adoption is jais. The brother will not get.
So if Halima was not the adopted child, but the real child, it would still be the same.
Yeah. And law of adoption is very strict in the UK. It's like a biological child. So, now, what happened? Next page. If you were to distribute that Islamically, compare it now. What would have happened? So 450,000. Islamically, the wife gets how much? 1/8. Halima gets how much?
Nothing.
Nothing, because it's not a biological child. It's an adopted child. Farooq gets how much?
1.
Farooq is formed under the residuary. He gets everything.
Oh, because there is no
The brother.
child.
Right? Do you see the complicated contrast? Big, big difference. Okay? So this is what we are trying to say. That
in the Islamic will, if the person leaves something for the adopted child,
1/3. Maximum you can leave is 1/3. Yes. Yeah.
that has to be
Yeah. So do you see the contrast in testacy and Islamic law? If you
We
agree.
do, Sheikh. The question here is, if the will is to be according to Islamic laws, in this example, will that be an honorable will in the UK law? So,
If there is no objection, yes, you got freedom of testation. If there are objection
objection
from the wife, for example, any will can be challenged. I will give you example later on, where the father specifically disinherited her daughter. The daughter won £200,000.
And also,
It's
please elaborate
217 case law.
If the
Appeal.
brother Farouk, his brother was in the UK or elsewhere, would that make a difference?
Now the law of domicile comes into play now to decide whether you can get it or so on. Yeah. Okay. We are assuming he's in UK. So when you don't have a will, these are the disadvantages, as you can see. It's longer to process the dissolution of the state. It can be 9 months, it go 2 years. You got no choice on executor, as I mentioned. You don't know who will be the court who will appoint it, who will be the trustee in case you want to make a trust for your children who are minors. You don't know who are the beneficiaries, who will be the guardian of your children. All these the court will have to decide. It becomes problematic. Then, of course, the longer it is, the longer, the higher is the legal cost. And these are not a small amount. If you are to go to an executor, to a lawyer, on average, those who specialize in dissolution of state, who are step members, that is Society of Trust and State Planners, it's approximately 2%. So if you have 1 million, they will take 2% of it to execute that will. Yeah, understand all the things. There are cost implications. So you got to take all those things into account. Then suit is, in certain countries, the executor must give a guarantee, the same amount of the, like in South Africa, for example, where I practice, there are some rules on that, right? So we got to be very, very careful that we don't leave this world without a will. All right, next please. Now, when you are married, with, of course, with your wife, you are married, there are 2 ways you can decide about your estate. One is joint tenancy. Joint tenancy is like this. For example, I got £50, right? So whatever it is, where is it now? I don't have my email. It's finished. Yeah. It means that this money, every part of that is co-owned. I cannot stay it and say, Sahab, no. So when I die, this whole 20 goes to my wife. That is joint tenancy. Is that clear? Tenancy in common, you say, no, you can stay it. 20% for your wife, 80% for you, or 50-50, or whatever ratio you want to make it. The difference is, one is a rule of survivorship. That is, whoever survives, the property automatically goes to the other one, number one. Number two, in the case of tenancy in common, you will have to realize that with the person who dies, automatically it does not go, his share does not go to the other party, it goes in his inheritance. In joint tenancy, it does not go in inheritance. In tenancy in common, it will go in inheritance. So, to be on the safe side, if you're worried about this, you make tenancy in common. But however, if you have a mortgage, then it becomes a bit complicated. So that we discuss with your lawyer. I'm not going to advise it here, right? Is it okay? Tenancy in common and joint tenancy between you and your wife when you buy a house or business or whatever, right? Make sure about the things. So if you got a business, does not mean your wife got half of your business. No. You got to look now, the business, a limited liability company, you must see how much shares she got, how much a share you got. It's a different game. I'm talking, for example, you buy a house. Your attorney, your solicitor will ask you how you want the house to be. Joint tenancy or tenancy in common. This is how it goes in practice. All right? This is where I ask this question, do we have a matrimonial regime in Islam? My humble reading, no. As we understand it in UK, in France, and many other jurisdictions. And the advice I give clients, if you really love your wife or you love your husband, and you want to make it half-half, you can make a shirkatul inan. That is, it will give the effect of joint tenancy. It can be half-half, it can be 40, 60, you decide, provided it is properly drafted, and I would advise you to have it notarized by a notary so that it got legal effect, right? And make sure you sign it, and very, very, very important, there is no undue influence. Tomorrow you die, somebody must not say there was undue influence, somebody forced you to sign it, therefore this document is not valid. So make sure all those precautions are taken. Yeah. I'm mentioning one technical term here, lawyers know what I'm talking here. These are very serious issue in our community. For example, very common in UK, and I'm sure you have read it in the newspaper. A person is in an old age home, care home. After his death, everybody got the shock. The nurse who got everything. The nurse who was looking after him who got everything. How? It is undue influence or not. So now the family will sue and say, no, this will is not valid. There was undue influence of the nurse on him. He was a patient. He was suffering. You understand? So undue influence, these are things that we see. I'm sure you have read it in the newspaper, right? So we got to be very careful. So when you and your wife are working together to bring up a home, to develop the common home, to send the children to the university, to pay the mortgage, to pay the bills, this is a pure reality of UK. The average person, husband and wives are working. Illa mashallah. Those who are well off, those who are very pious don't want to go and work. But the reality is in UK, husband and wife are working to make the house run. That's the reality. Right? A person working in a factory, brothers, how much is getting? 10 hours, £10 an hour, approximately. Yeah. Work it out. Your rental is 1,000 something, maybe 1,500 for 2 rooms. Yes. How on earth you make the end? And tomorrow you're telling me the wife got nothing? You follow what I'm trying to say? This needs to be sorted out while you're still alive with your wife. And vice versa. Not after death and then children and wife, children and father are fighting. So this needs to be attended while we're still alive. Right? There are so many cases in court on that. Believe me, right? Maybe you don't know about it. Those who are in the field know what we are talking of, right? Okay, next. Reza and Amina are court married and own their flat jointly as beneficial joint tenants, joint tenancy. They have a child called Salma. Reza dies intestate, leaving the jointly owned flat worth 300,000 and 50,000 in shares in his own name. Determine who receives what amount in English law. What gets how much?
300,000.
270,000.
Plus half of 50.
Then left over 50, yeah, so
And then 25.
275, yeah. And the 50,000, what happens to that? That's not jointly owned.
Shares.
That's
Remember what I said?
half of
She will get, yeah,
half of
okay. So this is in the UK law, right? So the flat goes automatically to Amina. This leaves an estate of 50,000, which also goes to Amina as it is worth less than 270,000, right? Salma inherits nothing. Even if there was a will, the house will still go to Amina due to the contract of joint tenancy. So automatically, because of joint tenancy, she gets it. Rule of survivorship, right? You understand? Because it's joint tenancy, she gets it. So this 50,000 is less than 270,000. It's a different contract, she gets it. And the girl gets nothing. Now, suppose you want to do it Islamically. Forget about joint tenancy now. 300,000 plus 50,000, that's made 350,000. The wife gets how much? 1/8. The daughter? There is no son. She gets half. Now, 1/8 plus 1/2 is how much? 1/8 and a half, 16, 8, 9. 9 over 16. So we're left with 16 minus 9. 7 over 16. What happened to the 7 over 16?
Brothers.
No, there's no brother there. There is a concept in Sharia called, we got the doctrine of return. The doctrine of return says the spouse will not get more than what is specified. But what is left over, you got to recalculate it, send it back to the existing shares beside the spouses. So it will end up with the daughter. All right? There's a mathematical calculation. We're not going to do that there. So the point I'm trying to raise here is to make you think. It's not that easy. Okay, when I die, they decide, the children will decide. It's not like this. Reality is something else. Yeah? They will fight, and then the small Sahab, then Mufti Sahab, and then the Mufti will fight among themselves. You know what I'm trying to say? Because, of course, you will go and get a Mufti who sides with you. Fatwa shopping. You know what I'm trying to say? So this is the reality of things. Yeah? So avoid all those things, brothers.
So if you have joint tenancy, couple of properties on joint tenancy,
Yeah.
right? But you're not court married. But because you have joint properties, is that not good enough or sufficient evidence that you are essentially single partners?
Yeah, joint tenancy doesn't have to do with marriage. Two chartered accountants decide to buy property as they want to use joint tenancy.
Which means the
It falls under law of property.
Okay.
The Property Act, I think, of
the one who
1925.
survives gets it.
Sorry?
The one who survives gets the
Yes.
other.
When you bought it, they tell you the ownership is jointly owned. It's got to do with the law of property, not law of marriage. You understand? So we're bringing law of property into marriage. This is why I'm saying, do we have a matrimonial regime in Sharia? If we don't have, we've got to think about it. Because the scenario in Europe is different. I'm not saying to change Sharia, not what I'm saying. We've got to find a solution how to resolve those problems, right? Okay. Now, according to Sharia, because of time, there are so many verses of the Quran which says Allah has decided who receives what. This is in Surah An-Nisa. Unto males shall be a portion of that which their parents and others near of kin may leave for them, and unto females shall be a portion of that which their parents and other near of kin may leave, whether it be small or large, a portion others. This is one verse. Allah tells you it's already determined who receives what. What you call in continental law mandatory heirship. Like in France, it's the same thing. It's already decided by law, right? In Germany, you go. In UK, it's not like this. You got the freedom of testation. In continental law, in France, only 1/4 you can decide. But the law, the Napoleon Code already decide who gets what. Yeah? So same thing Sharia is telling you, who gets what. It's a different legal system, right? There's nothing to jump. Okay? Next. The Hadith of Islam says that learn the law of inheritance. Because this will be the first knowledge that will be taken away from my ummah. And as you can see here, everybody is looking at me. When we talk about law of inheritance, we're talking about shares, we get worried. We don't know about it. Most people, 99%, with a conservative figure I'm saying, people don't know about this issue. Right? Then Rasul says the first part of the useful ilm knowledge which will be taken from my ummah will be this, ilm al-faraiz. Then Rasul says, learn the laws of inheritance with the same sincerity as you learn the Holy Quran. This is quoted by Imam Darimi. Then you get another verse of the Quran that says, وَمَن يُطِعِ اللَّهَ وَرَسُولَهُ. Whoever follows Allah and His Rasul concerning those matters, يُدْخِلْهُ الْجَنَّاتِ. Allah will make him in Jannah, enter him in Jannah. تَجْرِي مِن تَحْتِهَا الْأَنْهَارُ. Under which there will be the flowing rivers. خَالِدِينَ فِيهَا. He will always even remain there in the company of Allah subhanahu wa ta'ala. تِلْكَ حُدُودُ اللَّهِ. These are the parameters set by Allah. وَذَلِكَ الْفَوْزُ الْعَظِيمُ. This is the real success. So if you write a proper will, that can be your Jannah. That can. I bring a hadith later on. You will see what I'm saying. Inna Allah kana aliman. Then Allah was a faridata min Allah. This is an order from Allah. Allah says, Aba'ukum wa abna'ukum. Your fathers or your sons. لا تدرون أيهم أقرب لكم نفعا. You don't know who will die first and who will benefit from who. Allah has decided that. Because we don't know, we don't have ilmul ghaib. So Allah has put a system there. And this system is so scientific that even the Orientalists like Sir Ramsay, for example, who translated the book of Sirajiyya, he said this is the most sophisticated law of inheritance or succession in the world. Not one. I can give you many Orientalists, professors in universities. The system is so systematically calculated. Okay, then Allah says, whoever disobeys Allah and Rasul and transgress the limit, Allah will enter him in the Jahannam, in the hellfire. He will stay there, and for him there will be a very sharp, serious azab by not obeying the law of inheritance. No, next, please. Now listen to this hadith now. Very important. And Jabir was a Jadilul Qalb Sahabi, great Sahabi. He reports that Rasulullah sallallahu man mata ala wasiyatin. Listen to this, very beautiful. Whoever dies and making a wasiyah, make sure things are distributed, right? Mata ala sabil, he dies on the right path, was sunnah. Wa mata ala tuqa, who makes some precaution he took, right? Wa shahada. وَمَاتَ مَغْفُورًا لَهُ. And whoever dies on this state, he dies as a forgiven. This is by Ibn Majah. Next. This hadith was reported by Abu Huraira, the champion of narrators of hadith. He says that, إِنَّ الرَّجُلَ, and listen to this hadith properly, and this is reported by Imam Ahmad and by Ibn Majah as well. Rasulullah says, إِنَّ الرَّجُلَ, a man, verily a man, لَيَعْمَلُ بِعَمَلٍ أَهْلِ الْخَيْرِ. He has been doing a lot of good actions for 70 years. For 70 years, these have been only good actions. Right? But فَإِذَا also, when he started deciding the distribution of his estate, هَافَ فِي وَصِيَّةٍ, he started making nonsense. فَيُخْتَمُ لَهُ بِالشَّرِّ. Allah sealed his action, these 70 years. Allah seal it, Allah make it become, seals his action as bad, and Allah will enter him hellfire. وَإِنَّ رَجُلٍ, there is another person. لَيَعْمَلُ بِعَمَلٍ أَهْلِ الشَّرِّ. He's been doing a lot of guna, drinking alcohol, making zina, backbiting, just by, for 70 years he's involved, he's subsumed in guna, in sin. But فَيَعْدِلُ فِي وَصِيَّتِهِ. He makes justice when it comes to distribution of his estate. فَيُخْتَمُ لَهُ بِخَيْرٍ. Allah will seize his action as a person who has been doing good the rest of his life. أَمَلِ فَيُدْخِلُ الْجَنَّةِ. Allah will enter him Jannah. That is the power of observing the law of inheritance through our way. Brother, I'm going to ask you a simple question. Simple question. What are the pillars of Islam? What are the pillars of Islam? Shahada, prayer, Saum, Zakat, Hajj. These are the pillars of Islam. Do we have the law of inheritance there? No. Check the entire Quran. Which law Allah has given more detail? Law of inheritance. Does not that ring in our head, in our ears, the importance of law of inheritance? The detail, law of inheritance is not the pillars of Islam, but the detail Allah has gone in that field is more than Salah, Saum, Zakat, Hajj, Shahada. Why? Question we have to ask. If it is not a pillar, why Allah has given so much detail in the Quran? Because it brings societal equilibrium. It brings societal distribution of wealth. It removes the poor people from poverty into more financial stability. Right? So we have to understand the rich distribution of wealth in Islam. Let me finish the wasiyah. Let me finish this wasiyah first, yeah? Let me finish it. You just say it's a bit too. Is it too heavy for you?
No,
You coping? Okay. Okay. Yeah, give me 10 more minutes. Yeah. Okay. This was about the will, where it's a written expression of your wishes, how you want your estate to be devolved after your death. Now there is another question called wasiyah. What is a wasiyah? A wasiyah is a bequest. What is the difference? Inheritance is when you die, who will receive what is already decided. That is inheritance. Wasiyah means from what you got, Allah subhanahu wa ta'ala is giving us a chance up to 1/3 of the value, total, the net value of a estate to give to whoever you want, provided it is not an heir. That is what you call in English law a bequest. You call it a bequest. This is why I'm very reluctant to translate wasiyah as will. A will is a whole entire document. It can contain your wasiyah. All right? It's not the same thing from my humble opinion. Next. So this one. So you make, go fast. You can make a wasiyah, for example, during maradul maut. Say, for example, you waive your entire debt and you are a cancer patient. You can't do that. Only 1/3 will go. Somebody owes you debt. You can say, I'm waiving my debt. No, only 1/3 because you're in a maradul maut. You're in a state of terminally ill, as a doctor will call that person. You cannot give 100%. So you can up to 1/3 you're going to limit it. Payment of fidya for salah, Sawm, hajj, outstanding. You owe Allah. So say for example, the hajj nowadays is costing about 10,000-15,000. But if you cannot exceed more than one, if this 15,000 is more than 1/3 of your estate, you can't do that. You've got to do for another means. Only 1/3 can go to pay your hajj or whatever, your zakat. So you can put it, but that is not inheritance. That will go in this 1/3 to compensate for our shortcomings. Payment of kafara, penalty for violating long oath, fast, and so on. So all this can be paid because you have delayed it, we delayed it, now death is coming. So what to do now? We cannot compensate. So okay, we are going to compensate that financially, and therefore up to 1/3, ulama say, you can do that. This is where wasiyah is very, very important. How to use it, when to use it. Next.
Sorry, is there any limit for bequest in the UK?
One. No, you can give everything to your dog. People are doing it. They're giving half of the thing to their dog. The law allows it. No problem. Yeah. Okay. Jim.
One question. Children under the special guardianship order in the UK law, do they inherit?
If it's your own child, yes.
Not
But then the guardian will have a right to monitor that money because he's a minor. Yeah. Then of course there is the rule of curatorship and so on. That's another rule that comes into position. Yeah, where somebody will manage it for you.
You have a child under the special guardianship order with you. It's not your own child.
Ah,
Do they inherit?
if
Adopted children inherit, as you said earlier. What about that? GO.
under English law, if there is a will, yes. If it is an adopted child, yes. Under English law. Under Sharia, adopted children don't get. You have to make a wasiyah for them if you want to give them. They are not automatic heirs. Yeah. Okay. Important rules of wasiyah. We use quickly about this. Legal heirs do not receive wasiyah. Your wife cannot get your bequest. Your son, your daughter, your spouse cannot get a bequest. They will inherit what the Quran have said or the Sunnah. If amount is more than 1/3, then executor should limit it to 1/3. So if you have exceeded this 1/3, your executor must limit it to this 1/3, unless the heirs consent to it voluntarily. If there is no heir, then the entire estate can be made a wasiyah. Now, the entire family is going in a plane. There's a crash. The whole family is gone. So before you go, you have written it that in case I got no heirs, I make what you call a residuary gift. I'll come to that later on. If there is no heirs for me, you give it to an orphanage or whatever, right? Okay. Wasiyah for non-Muslims is valid. Yes. So many people, for example, in UK, they are married to Ahl Kitab. According to Sharia, the Prophet said, a Muslim will not inherit from a non-Muslim, and a non-Muslim will not inherit. Listen to the word, inherit. But the wasiyah you can. Okay? In the case of a mixed marriage, all right? Wasiyah can be revoked, very important. You can make a bequest, you change your mind, you change it. Whereas for inheritance, you cannot change your mind. It's already there. Okay, next. Now, there are 4 types of wasiyah. One is mandatory, in the sense that you haven't performed your hajj, it was further on you. Make sure you make a provision that people go and make hajj for you. They call it hajj badal. Yeah. Mustahab, at times is mustahab. For example, your dafan kafan, how you're going to be buried. There is cost involved there, right? Usually this kafan dafan comes from the estate, by the way. People don't understand that, from the deceased estate. So this is why we got to make provision for that if we can. Our kafan dafan, because now a qabr costs about 6,000 pounds, isn't it? A grave costs about 6,000 pounds. Where you got 6,000 pounds? Overnight, you know? You got a heart attack, na'uzubillah min dhalik, and you are gone. Who will get 6,000 pounds for you? So we have to make the provision for the things. Yeah. Then jais, make a wasiyat of all things which are permissible, such as who will perform his salatul janazah. You can. You can make a request, so and so. You make a wasiyah. It's not money. It's not monetary, this one. The akabir of the past, their wasiyah was, the will was full of wasiyah, advice to the children. Yeah. Then some are haram. When you make such a wasiyah, which is exceeding 1/3, you call it a bequest, you know the court will implement it, and you are taking the haqq of an heir, that is haram. You can't do that. Okay? So we shall take a small break here for 10 minutes.
Yeah, the refreshment is ready in the corridor. So
Okay. So can you come at, time is tight. Okay.
They can take the refreshment and come back.
Okay, please.
Yes.
Because we are really running short of time. 8 o'clock I got to go. My train is 9:30.
Sorry, I have to disturb you. So, going back to this court marriage.
Brothers, you can have refreshment in the corridor. Don't bring it inside because of the carpet. So 5 minutes you can have refreshment and come back.
Husband and wife in the UK, 2 decades or more, have joint property. Joint property. But they're not called married.
Yeah.
Under the English law.
Yeah, joint tenancy stands. Joint tenancy got nothing to do with marriage.
No, but that's only one part.
Yeah, it's
Now-
ownership.
Now the other part of the wealth, right, which is not properties, limited company,
Yeah,
bank.
that depends what are your shares.
So that
already
goes
decided. It's
that
your
goes to
ownership.
my state. That goes to the
Yes,
state,
if you
right?
die, go to your state.
And because we are not married,
Yes.
essentially, it should not be considered,
Yeah, if you're not court married, it will be problematic.
right?
This is why we have to make a will. Exactly. This is why we have to make a will.
Yeah.
The whole purpose here is a small problem like this becomes problematic. Big way after your death.
So no, I mean, if you have, I mean, there is evidence you lived here for many years together.
You've got to go and prove that to court. Go and prove it to court. If
Right.
somebody doesn't like your face, your brother, for example.
So it
You
becomes a
challenge it. What are you
litigation.
going to do?
So it becomes a litigation, basically. Okay. So it can become complex. Essentially, if someone
So
gets,
the court will treat you as cohabitees. There is something called the trust term in law, what they call it. There's a term in law when you are cohabitees regarding in your state, you make a trust, you put it in a trust, and that trust protect both of you.
but is it not, I mean, we've heard of this very common perception that if you have lived together for this long, for 7 years, I believe, then you considered as same partners.
There was a court in the case, very famous case, Khan versus Akhtar, 2018.
You mentioned that, yeah. I'll read about it. Yeah.
When the wife fought, her husband said, no, you're not getting anything. Okay, but I stayed long with you. No, the court says no. What? Appellate division.
Or they both were alive. Or Oh, they both were alive. Okay. So it was not after the passing
Yeah.
of Mr.
You got to go and prove it's an unnecessary problem. You are not recognized in the law as a wife.
You're only cohabiting.
How about you?
You live together, but you're not.
You are cohabitees, and cohabitees are not protected in law.
Assalamu alaikum. How are you?
Yeah.
Do you, sorry, you'll speak.
No, it's fine. I'm in the middle.
Do you offer any services as well?
Yeah, that's it.
I do, but usually I'm quite busy, I'll be honest with you. I will refer, I can refer you to somebody else.
I have the Firani tailors taking care of the Firani tailors. Solicitors, they are taking care of the inheritance. But I'm not very convinced about what they are doing. Though they are being advocated by big ulama.
You see, they don't want to be in a conflict with other ulama, I'll be honest with you. Me, I run a consultancy. Usually, I'll be honest with you, my clients are big. I've got big clients, right? All my clients are corporations. I don't deal, but if people want, I got friends who are good in that field. I can refer you. I can refer you.
I think the devil is in the detail, and I think where it gets complex is that you wrote a will according to Islamic laws, and that gets challenged under the English law. So you've got to find that middle ground.
Any will can be challenged.
No, but obviously you work on probabilities. What are the chances of having this challenge, and what are the chances of it working?
Sheikh, so one thing, practically, how do we apply this? Which lawyers do we go to? What do we tell them? So I understand the important, but for us, like, we're
I will give you the main thing to consider. You go to the lawyer, tell her or him, this is why I'm not. If you don't find a lawyer, I will refer you to somebody. Me, I won't have time for you.
No, I know. So, but as long as
I can do it, I don't have time.
No. So, can you refer someone? I appreciate you.
Okay.
There must be some good people here in England that do this.
The two categories of people who can do that. One is a solicitor.
Yeah.
Then it is what's called a step member. They are specialized in that. They are regulated. A step member, STEB.
Yeah, you see, the trouble is, I mean, we think solicitor also, it's a very complex area. And more you talk to them, then you come to another, they hardly know anything.
Fully engaged, alhamdulillah.
So the other thing is, do you have like a playbook or something, like some publication, some PDF document, which we can say, when we speak to a solicitor or when we speak to a step member, this is what we want, based on the guidance of the Sharia, this is how I want my will to be written out, and this is my wasiyah.
Let me give you my card. Then you email me. Don't call me because I'm traveling now.
I'll email you, inshallah.
And then I'll refer you to somebody. Yeah? Sorry. Do you mind a female lawyer? Do you mind a female lawyer? Okay.
Because alhamdulillah, your talk is timely, because I was in the process of doing my will. And there were some questions, and I said, you know what, I know there are some very specific things I need to keep in mind according to Sharia. So I said, give me a few weeks because I'm traveling as well. And then alhamdulillah, your talk was advertised, and I thought maybe this is, subhanAllah, this is like a blessing in disguise, mashallah.
You've got a long journey ahead, Sheikh.
Yeah, but then all the people on Facebook will see me eating.
That's fine, they're expecting
They
more.
might come, but they see you eating, they might tell you.
So you're taking the train back to France, is it?
No. You're going to France? No, I'm going to Leicester.
I'm going to the US.
No, I'm going to Leicester. Next month I'm going to
Because
Malaysia.
because on the invite they didn't say whether the recording is available or not. And this was so important that I said I have to come and listen to it. And then tomorrow morning I fly out.
But just look at the basics. Of course, this is not tip of the iceberg.
Yeah, but when you speak to solicitors, like if I'm speaking to an English lawyer, right, they wouldn't know all of this. they gave me the basics about mirror trust, about a mirror will or establishing a trust and all of that stuff about leaving something for
How much are charging you for the trust?
I'll tell you exactly. So trust will and lasting power of attorney, £1,800. So
In London firm, right?
yes.
Yeah, it's a good price.
So there's something I think there's a financial LPA, then a health and welfare. So both. So for each LPA, for me and my wife, it's 544, and then times two, 1,088, and then I have to pay registration, and then mirror wills plus is £1,300. So see, even on my notes,
Brothers,
I've
if you
written,
can come
I need
in
to ask
to
about
start
Sharia
because we
compliance
are
of
running
wills.
late.
So I
So
told
the Sheikh must
that look, I have to go back
move back
and
at
check.
sharp 8.
So, but at least as long as I know the nuts and bolts, I can advise them that this is what I want, and then. So the trust will is 795. 795 including VAT. This is from Qual.
It's good.
Yeah.
Usually they're charging 2,000.
Really.
Just to make the trust.
And this will include going to the land registry and then doing it, tenancy in common rather than joint tenancy. So they can
Brothers, if you can
they
come
can
in,
make
please.
instructions to the land registry that these changes need to be applied. So at least one night, inshallah, I'll ask the brothers to
They
take
will
this, and
charge
I will forward this to my solicitor. Maybe this will educate them as well about more about Islamic, because alhamdulillah, this is da'wah as well for us, right?
But you can find Muslim solicitors as well.
Probably is a good price.
I'm working through a financial advisor, and they know, and they're trying to also do an education and maintenance trust for the children as well. I mean, they're advising me a lot of things, but I need to
Brothers,
see what
we
is
are
Sharia
running
compliant
late.
and what isn't.
Please.
The food is more important than the will.
SubhanAllah, the chai is amazing. The chai is amazing.
The SLMCC chai is really
Really?
SLMCC chai.
I normally do chai duties on Eid, I have to make it in that
There's a special
bakery.
type I had in Dubai, I can't remember. That was quite good. I have a special name. Sheikh, do you know Ahmad?
He passed away now. Rahmatullah alayhi.
Because I read somebody here from South Africa, right? South Africa?
Me? Yeah.
He was also from South Africa.
Yeah. He's from Durban. Met him.
Oh,
From Verulam, near Durban. He's a place called Verulam. He was from there.
Brothers, can you come in? We have to finish at 8.
Samosas are there, so nobody's coming. Sheikh, everybody's running for samosa.
I hope they're not filming me.
MashaAllah, may Allah bless you. This is,
Halimi sir, can you close the refreshment?
I'm almost 50 and I'm only beginning to realize how important this is.
You know, I go masjid, I give this lecture. Usually, I take an expert in tax law with me.
I did write on we run a musalla in Rice, Arif, I know, and I did mention that people should try and attend, but if there's a recording, inshallah, we will post it on our
Yes, it is
on our
recorded, yes.
Muslim group, and I will definitely advise everyone else to gain benefit from it, inshallah. Maybe you can upload it on YouTube.
It is. And the SLMCC website as well. So the link is there.
Live?
Yeah.
Allah.
This is the YouTube.
Because you're not getting meeting.
which one would you recommend?
I'm developing a course on that.
Okay.
Yeah. A full-fledged course on what you call wealth management. On wealth management, about 12 hours only on wills. Then there is inheritance. Then there is family office. So when you click on my website, it's not ready yet. You will get about 12 options. What course you want, you pay, and then you follow the course.
Okay, so do we have to register and then?
Yeah, you have to pay.
Yeah.
There are people employed. This is a company.
Okay, inshallah. So that's good. It's on Minara.
Min Academy, no.
What is
This
it?
one is for consultancy. Education is Minar Academy.
Minara Academy.
Yeah.
Yeah.
You can contact me on this thing. You see, inshallah. I think we started. The cameraman is not here. I don't think so.
Sorry? Yes. The break was also live.
Huh?
The break was also live.
I think so. I don't.
No?
How can you make break online? The break online Facebook.
No, that's later we share it.
No, it is now
I
live.
don't think so. I don't think so. Wait a second. This, no?
It's already
No,
okay. Cut it. Huh?
no.
Well, let me start it now.
Oh, yes, that's function.
We start? All right. Bismillah ar-Rahman ar-Rahim. We're starting now. The second part, we are running late. In 30 minutes, I got to finish quite a lot. I got about 20 slides to finish. So now, let's see under English law. So you have seen the importance of having a will. You have seen the importance of having Islamic will. Now, I want you to focus that we are staying in UK. UK got its own requirement for your will to be valid. And there are many acts of parliament on that. I'm not going to go into detail. I just focus on what you got to know. First of all, under the Wills Act, 1857, your will must be in writing. It must be in writing. Number two, it must be signed by you. You must sign it. I had a case when I was practicing law in South Africa. A father left 4 wills. He never signed anyone. He never put any dates. We didn't know who gets what. And it was a big, big problem in court. So make sure you sign it. Okay? Number 3, you must have 2 witnesses. They don't have to read your will. They got to make sure that you are the person who have signed it. That's the purpose of the 2 witnesses. And make sure that the witnesses are not a member of your family who will be an heir. Your wife cannot be a witness. Your children cannot be a witness. Your father cannot be a witness. Understand? These are the conditions of UK law. Next one is your mental capacity. Please, brothers, listen to me properly. If you look at the statistics of UK, we're having an aging population. An aging population means, in practice, we've got experts sitting in over us, our cognitive, we're having a digressive cognitive. We cannot think. We have dementia. We have all type of disease, mental disease. What would happen under English law if you cannot understand what you are signing, what you are giving away? This will be challenged. I personally had to give a legal opinion on a case, a multi-millionaire, not to say billionaire, I think he's a billionaire, where he had 2 wives. one wife, children were not so well off, were not so mature enough. The other one was a big gap in age. So they challenged that the father, the will that he was doing, his action, everything, he was having a starting of a dementia, the starting point. There are 3 stages of dementia. They were challenging that, and they were challenging all the documents he signed. I'm not talking of thousands, I'm not talking of millions, I'm talking of billions. Right? Because of dementia. So you got to make sure you got the mental capacity. So if you are afraid that children can challenge it tomorrow, Mr. A can challenge it, make sure that when you draft it, you can go to a notary or a lawyer, that you are signing it and you know you are in your senses. You know what you're signing. Make sure this. I got another case where a person challenged the will that this man was his old age. He doesn't know what he did. He gave the house to Mr. A. Mr. A doesn't deserve that house. But Mr. A was very sharp. Mr. A got, when the man went to sign, he made it sign, he knows what he was signing. He presented that in court, he lost your case. He got the house. So these things are happening in society. You will only understand what I'm telling you when you be subjected to that. Yes, yes, yes. Right now you don't understand what I'm talking because it's not haunting you. It's not haunting you. So take this precaution. So mental capacity. Next. You got to do it voluntarily, no coercion, no undue pressure on you, right? And one thing which is not in the act, always revoke, have a revocation clause, because you don't know what you did when you were 20 years ago, 30 years ago. So revoke. Know what you are doing. That was your final document, right? Next. Now, the condition for a will to be valid, number one, you must be 18 or above 18. You must be sane. You must be free, no coercion. You must be mentally sound and understanding what you are making a will, because the mental diseases are increasing in UK. We're having an aging population. Know the nature and extent of property and potential beneficiaries. It must be in writing, must be signed by the testator. How 2 witnesses at time of signature. Witnesses must sign after the signature of the testator. You can add an attestation clause, they say, that is, I have witness that he is existing. If you want to put that attestation clause, and a witness or his spouse cannot benefit under the will. So this is what I've said. So these are the conditions that if you are to draft a will, for it to be valid in court, provided it's not against public policy, it will be okay. Right? These are the conditions that when you prepare a will, you go to the probate officer. It must be writing, it must be signed, you must have 2 witnesses, you must have the mental capacity to prepare it, you must be above 18, this type of things, right? This is the law in UK. What you put in there, the law gives you the freedom. Who you want to give what, the law gives you the freedom, provided it's not against certain policies in UK law. Next, please.
So it doesn't need to be notarized.
No, doesn't have to.
But it's better if it is.
Yes, if you want. Right. In any case, a solicitor is an officer of the court. He is regulated by the Solicitor's Regulation Authority. So all this got value in court. Yeah. Now, there is something about the legal capacity. I'll take the position of Ali To's article here, which I got from LinkedIn, which I found very, very, from a law website. The question of mental capacity. I'm not going in depth with that. I need about 30, 40 minutes to explain only this word. There was a case in 1870 called the Banks versus Godfellow, where the court says when you talk about mental capacity, it means understand the nature of the act of making a will and its effects. You got to understand when you're making a will, what is the implication? Who is getting what? Number 2, understand the extent of the property of which they are disposing. Right. Number 3, be able to comprehend and appreciate the claims to which they ought to give effect. Number 4 is a problem here. Not be suffering from any insane delusion or disorder. Look how the English law look at you. Want to protect you, protect your estate. Why I'm saying number 4? Because this is 1870. There is a mental, next please, we have the Mental Capacity Act that came, and there they gave other conditions that caused some havoc, it caused some confusion. There was few cases I went to court because of time, I'm not going there. So there was a presumption of capacity, where it is important to remember that both tests operate on the basis of presumption of capacity. Under that case of 1870, that is, you can appreciate what you are preparing, what you are disposing, etc., is in its place. On top of that, medically, you must be okay. You are not suffering from mental disease, depression. What about, there are so many diseases nowadays, right? Because if not, this will be challenged. So the law is protecting you. The law is not complicating your life. The law is making things easy. You don't go unnecessarily wasting money in court. So this is the way to look at it. When you have an act of parliament, the government wants to make things in order for you. Okay, next. So what do you do? When do you update your will? So these are very important. When you get married, marriage can change who will get what. Right? When you go divorce, divorce also, if you have a will, you haven't changed the will, your ex can claim. You've got to redraft your will. Yeah, okay. When you have new children or other relatives you wish to benefit, for example, nieces, nephews, you want to benefit them, with time, you want to change. Have bought a new property or have recently obtained expensive assets, buy a new car, etc. So you've got to relook at your will. On average, we tell people every 2 years, check your will again. If you want to change it, you change it. Yeah? So these are events that will have an impact on your will. Next. Now we come to the last part. As Muslims, what are the main things that worries us? It's not about this world. It is that we're going to have Hisab Kitab, we're going to pass away one day. That is our concern. So when we draft a will, first thing, you got to identify yourself. You are Mr. So-and-so or Mrs. So-and-so, you are a Muslim or Muslimah, and I think it's important you say you are a Muslim. Why? I personally have witnessed cases where people embrace Islam, right? They revert to Islam. Their body, the family did not want to give their body. We could not bury them in the Qabristan, in the graveyard. And there are Muslims there. We had to fight. Then about midnight, the body came. Yeah? So these are very, very important. Yeah? Recently, there was a case where a man got married to Ahli Kitab. Okay, he can marry, that's his Quran, no problem. But the wife now doesn't care about burying the body. Because the burying the body, which means she got to pop out 6,000–7,000 pounds. Cremation is 1,500 pounds. It's the economics of burying now. Do you understand? So if you highlight those things in your will, it's good. Now don't give a long khutbah in your will, please. At time I read some of the will, 2 pages of khutbah. You send that to the probate officer and say, what is this? That you can have it, give it to your children in a separate document. That you don't send to court. By all means, give advice to your children. The judge of the court is not interested in your khutbah. I've seen that. I say, what this man is doing? 2 pages of khutbah in his will, and then 1–2 lines. What to do? I don't say don't do it. Do it the right way. Understand you are not in Islamic State. You send that to the court will say, oh, it won't understand what you are saying. Yeah. Okay. So that is important. Number 2, revoke any previous will. Even you did not have a will, put it there that I hereby revoke all my previous wills and codicil signed by me. And this is my final will. Have a provision regarding your burial. Please, brother, this is what I'm saying. There are countries in Europe where you do not have a Muslim graveyard. There are countries in Europe. Alhamdulillah, in this country, Allah has blessed us We have all those facilities. We got to make لَإِن شَكَرْتُمْ لَأَزِيدَنَّكُمْ. We got to thank Allah for that. I'm going to add something on top of that. England is an island. Land is limited. The masjid committees must think seriously of having private graveyard. In Leicester, we are working on that. There are 2 masjids are working on that.
Garden of Peace.
Yes, okay.
Chigwell.
Because there is a limit council can give you land. Step back and think. Especially when cremation is under increase, we have about 300 crematorium in UK. 300. That gives you an idea how a big business it is. Why should we give Muslim to land? Right? So we got to think for ourselves. Right? You got to think of getting our own land. Of course, following the law of the land. I'm not saying to do things. No. Follow the law of the land, get the right license or whatever, right? Your burial is very important. Bury you as soon as possible. Why this is important, brothers? The hadith of Rasulullah. 3 things must be done ASAP. When a girl gets a good proposal, when a person passed away, and salah. You know about this hadith. Now often we have to go for post-mortem. And that delay, isn't it? It will delay. Now you can have, for example, MRI. Same doctor. It's easy. You don't have to do the post-mortem. You do the scanning. So you can make all those provision in your will. Maybe the masjid, I don't know whether in London you get MRI. You have it in London? No? Faizal. Come on, wake up a bit, you Londoners. You must talk to the government, the authority, and get one. No. Why we can't have it?
Yes.
Do you know by 2030, Muslim will be about 8% of the population of UK. According to some other projection, will be 10%. We're going to sit like this? Think what I'm saying. We can't sit like this and when I go, you go your side. And no, we got to take decision what to do, how to resolve this problem. How many people are dying per day? How many people are dying per day? Yeah. Think about these are serious issues. Not because we are young, we're going to die in 30 years, we don't worry. Nah. Anytime we can do. We have seen the pandemic. Young people were dying, isn't it? So we got to be serious about it, of having, after talking to the authorities concerned, to have our private qabristan. I'm telling you, in Leicester, it's full, no place. We went to Preston, yeah, same thing. There's a limit the council will give you, and we got to be realistic with that. There are other communities as well. Why should we protect only the Muslim? You follow what I'm trying to say? So we got to take some precautions, certain responsibility as a community, buy some land, take the appropriate license, and how to run it, etc. You can brainstorm this session. Okay.
So Rishi, how is organ donation and postmortem relevant to the will? What can you do in your will?
You say you don't, say for example, there's a postmortem, you say you don't want to be cut into pieces. You don't want to be resurrected in front of Allah, everywhere is cut with you.
See, the trouble is if you die and pass away in the hospital, there is not enough time for them to see your will, etc. They might have done it.
You can object. This is why if you have a will, your children, your wife, your spouse,
They should know about it.
they should know. If you don't have a will, of course you're going to end up like this.
But same for organ donation. I think it is
Yes.
a separate process that you have to opt out.
Yes. The law is they can take your organ. Of course, your
Unless
family
you-
and so on must approve. If you don't want, you got to opt out with NHS, but you can put it in your will. Not many people haven't. I've done it on NHS, but depend what your fiqh position on that. I don't want to go into those details here, right? Okay. A burial in another jurisdiction, that also is a big issue because they're going to burn your body, they're going to remove everything. It will cost money to transfer the body by the plane and all the stories. Do you want to do that? Some people are doing it for whatever reason. We got to think about it. Okay, next please. So first, identify yourself. Number 2, revocation. Number 3, your own body, your kafan, dafan, where to be buried, etc., your organ donation, whatever it is you want, you spell that. Next, appointment of your administrator. As I mentioned earlier, if you don't administrate, you're going to have a problem, you're going to delay. The court will have to appoint one, okay? So make sure you appoint somebody, as far as possible, somebody who knows your thing, maybe your spouse, your son, who knows your assets and your liabilities, right? Make provision for two, because just in case somebody dies or he doesn't want to do it, there is plan B. So failure, Mr. A, Mr. B, I hereby appoint Mr. B to be my administrator. Next. If you have any debt, make sure you pay those debts. I've discussed on that enough, right? The question here is, if you got a zakat, just a brain teaser here, somebody owed you, right? And after you die, before your burial, that debt comes in your bank account, that money comes. Do you pay zakat on that? Who pays zakat on that? I won't give you the answer. Think. Also, have an appendix, because don't expect the executor to know all your debtors. Usually you put an announcement, you put on the newspaper, whatever, give you 3 months delay, whatever. But make it easy for them. Okay, next. After you finish all those things, then you write your bequest. You want your sadaqatul jariyah, you want to give an orphan, you want to give your kala, you want to give to masjid, whatever you want, this 1/3 is limited to 1/3, that you put it there. If you don't put it there, you won't get it. And I personally believe, my personal opinion, I'm not saying that in a bad way. After your death, you don't know what your heirs will do. Take your own precaution, create your own sadaqatul jariyah. Take my advice. You don't know what they will do with your money after your death. We make dua, we get good children, they will honor us. We don't know. Yeah. So take your own precaution, make your own sadaqatul jariyah, whatever you want. Okay. Yeah, okay, next. Bequest, next. Then after you finish it, so first identify yourself, revocation, your burial, your body, then your administrator, then debt. In debt, please, 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 brothers, many people don't realize it. If there is inheritance tax, or there is a tax assessment, make a provision, because this will form part of your debt. You cannot distribute your estate unless and until you sort out your affairs with HMRC. Understand what I'm saying? Do you understand what I'm saying? So make a provision for that as well, right? You follow what I'm saying? If you die, the first person who have access to your estate is your tax people. They will get the money. There was a person, a child, he was playing with money, and the coin went in his throat. The mother got panic, tried to save him. There was a man in the, who was drinking his coffee, reading newspaper, he's relaxing. Nobody, they called the doctor couldn't take out the coin. The man came, he gave one shot at the back and the coin came out. The doctor said, how you did that? He said, I work in a tax office. Okay. All right. So then you put your miras provision. Either you mention who receives what, or like they do in South Africa, there's no problem at all. You say that a certificate will issue by Jamiatul Ulama or Mufti so and so, whatever, who is an authority in that, and that will be considered as your wish. And that certificate is valid by the Master of the High Court in South Africa. In UK, I have not seen it, but technically, under the freedom of testation, it ought to be accepted. I don't know. I'm saying that with reservation, right? Now, this is very important when it comes to miras. Any will can be challenged. In this case here, Elot versus the Blue Cross and others went to appellate division, where a father clearly mentioned that his daughter is not going to get anything. The daughter took the matter to court, challenged the will, because she was financially not well off. She said that under the maintenance of the family, my father had a duty to look after me. He cannot give everything to this charity. The court, if my memory serves me well, awarded £200,000 to her. So even though it was mentioned in the will, the court says no, what he's doing is not right. Because the maintenance of the family is an obligation on you. You cannot turn your back against it. There was another case I studied in South Africa where it was a Jewish family. The father said that you will tell the son, you will inherit provided you must marry somebody who is in our community. The son did not observe that. He married outside the community. So the executor said, look, you didn't observe what is there. He said, no. The matter went to court. The court says this is again the norm. You cannot dictate this person to who he must get married. So that clause was rejected by the court. So you got to understand those, how the court will look at it as well. Yeah? So there are so many case laws I can raise in front of you. There's no time here. So as a general rule, you do have the freedom of testation, but there are some caveat to that. Yes?
You mentioned that case was in South Africa.
Yeah.
There's a difference between South Africa and England. So like, in terms of religion, culture, and stuff like that, would there
I don't know. Do we have a case law on that in South Africa, in UK? I don't know how to research on that. I'm not so sure in the case of UK how to ask. Yeah. Okay, so this is a case. Now the question is, many people are worried about the miras issue. What some people do, mirror will, etc., etc. One of the ways I told people, if you want to do it, it's not an advice, it's just a suggestion. You go and see your professionals. I'm saying that with a caveat here. You can make a what you call a testamentary trust. You transfer everything that you have in a trust by the trust. The trustee must be somebody you really trust, okay? And you give him a letter of wishes what to do with what you what to do with your estate. You call that a letter of wishes. Some lawyers do that as well. Okay? The danger with that is if the trustee is not honest, he takes everything, he goes away. Because the trust law, it is his. So you have to be careful also. Yeah. Yes.
Is there any Islamic clauses that can also be challenged legally using the law of the land? For
Yeah.
example,
Yes, it can be challenged.
So it's not really guaranteed. And even if we have a legally binding Islamic will, someone from a secular perspective can still challenge it and say,
Yes.
from a feminist perspective, why is the man getting double the
Yeah, but you can challenge somebody who making the will in the name of his dog. People are giving their dogs. So anybody can make any will can be challenged.
Could that happen, and how can we ensure ourselves against it?
I mean, first of all, I said earlier, the tarbiyat of the children. If tarbiyat is not made, I can't do anything. Once they understood that, this is ahkam of Allah, Allah is protecting you. I could have drafted a will giving you nothing. But the ahkam of Allah is giving you something. That's the first one. Right? Under English law, you can give a stranger everything under freedom of testation. Islam says no. There's a bare minimum you must get. Number one. Number two, before you die, if you feel that one of your child or children needs something extra, you can give donation, hiba, what you call hiba. During your lifetime, you can give donation. Number two. Number three, you can make the letter of wishes. Right? So there are many ways to solve this problem. This issue about the girl getting half and this and that, it doesn't stand. Because look at what the other people are doing. You will get the shock of your life. Their family don't get anything. Islam is guaranteeing you something. Right? So it depends how you present it to the judge and this and that. Yeah? Okay? Yes?
I think this provision you have to use to actually execute what Quran is telling.
Yeah. Yeah.
That is when it becomes an Islamic will.
So I guess,
The divisions.
yeah, I mean, you mentioned the name of the heirs and so on. My only problem I have with that is, what if somebody died before you, one of your heirs? Then you have to recalculate it. Yes, the ideal position is what you are saying. You mentioned, okay, my wife will get this, my son Abdul will get this, my son Junaid will get this, my daughter Fatima will get this. That the ideal is very clear cut. That's the ideal solution. But if they die before you, that brings its own challenges. Right, okay. Right, next please. Protection of minors. Put in your will who you want to look after your children. Right? There are some fiqh issues there, ask your alim. Next. residuary gift. Allah protect us, na'uzla min zalik. If all the family goes, a car crash, a plane crash, whatever, and there are no heirs, always, always put a residuary gift. In the case there is no heirs surviving me, I hereby donate all my estate to masjid so and so or whatever you want. You understand what I'm saying? Make it there. If there is no heirs, is there heirs? Of course, this floor doesn't. You call that a bona vacantia in law. Okay. So this one as a residuary gift. Put it there. Just a safety valve. If you don't put it there, what happens? The state takes it. Okay. So why don't make sadaqatul jariyah with that as a provision? Yes. Okay. Next. This one is a bit problematic. Usually there are disputes when it comes to money, yeah, and children fight. If you want, I talked to a few lawyers and some judges. It's not a clear-cut area. Can you put an arbitration clause? The Arbitration Act of 1996 stipulates certainly few things you cannot arbitrate. Distribution of wealth and so on is not prohibited. And an arbitration is similar to a court, a quasi-judicial. When there must be a term of reference that the parties sign, and based on that you say, I want the arbitrator to judge according to Sharia, etc., etc. If they find Mr. So-and-so will give an award, it's not a judgment, you call it an award, and that award will be binding on the heirs. Will that be valid or not? I discussed with 2-3 senior counsel, some judges, they have the opinion, yes. Others say, how can you dictate from your grave what to do with other people's thing? That's a discussion. For me, I haven't seen a case law on that. There might be, I don't know. If anybody know, let me know. But I recommend people to put an arbitration clause, right? To mitigate unnecessary legal costs going to court and delay and delay and delay, you go and appeal. So poor guy, he had a one house. Nobody's benefiting from the house for the last 5 years, 10 years. Why? Because they are fighting. So you put an arbitration clause, khalas. Hopefully it will stand. Next, please. Some malpractices to be avoided, donation versus inheritance. Our community, we tend to tell the child, you know, beta, when I die, this house is yours. Betty, when I die, this car is yours. No, that's not the way you do things. If you want to make a hiba, under the Hanafi fiqh specifically, there must be offer and acceptance plus qabza. If I want to give you this bottle of water, I say, I'm giving it to you as a gift, you must take it, and you say, I have accepted it. If you haven't said that, it's not executed. So verbal statement like fathers like to make, be careful with that. If you want to give, you want to transfer, make the necessary legal document, make it. You want to donate during your lifetime, you want to donate. It will not go in inheritance, do it properly. Business goes to sons without proper documentation and evaluation. That's also quite ugly, you know. We assume because the brother has worked with the father, he automatically takes the business. Where is the agreement between the father and the son to make that assumption? And the sisters don't get anything. On what basis are we making an assumption? Is there a contract? No, we cannot make assumption. So we must be careful. Matrimonial regimes, which I spoke already, lack of estate planning. Make sure if you are to die, you plan, okay, life expectancy in UK, it's approximately 84 now. Approximately. You're going to die in 20 years' time, start planning now. You don't know when you're going to die, Allah who knows, we don't know, but plan. Right? Plan. Who will get what, when, what amount, start planning it. You want to make donation, there's tax planning to make, because 40%. It's a lot of money. Within the boundary of the law, start doing, estate planning is one thing, estate tax planning is another thing. These are experts who do that. I'm not an expert in that. You must see the experts. No undeclared money or offshore accounts. This is very common. People got offshore account, yeah. The Pandora box, everybody knows about it. I don't want to talk about it, yeah. So many offshore accounts. Be careful with that. And also, make sure that if you don't declare money, when your children, when this will come into your estate, what will happen? The tax will increase more. One is an inheritance tax, one is a fine on it. You understand? So you've got to plan all those things properly. Yeah? No tax provision in case of assessments. People don't plan this, that there will be a liquidity issue. 40% of your estate. Say for example you got 2 million, 1 million is exempted. On the 1 million existing that your children will have will be 40%, which is 400,000 pounds. Where your children will get 400,000 pounds. So you got to plan this cash flow. No cash provision to support wife during her iddah or even the family. Create a small account on your wife's name, your children's name, because your account will be frozen. Yeah? So these are small things take into account. Now the chronological distribution of estate which we have done, the burial cost, hadith below indicates role of estate, but in absence of estate, this is what the hadith say, I have more right to the believer than themselves. Whoever dies living dead, it is upon me to pay it off, and whoever leaves wealth, it is for his heirs. So Rasulullah, as the head of the state, took the responsibility of it. Now, in UK, that's not possible. You have to make some arrangement from the masjid level. There are so many masjids are doing that in UK, I know. So if somebody cannot afford it, the brothers must help, right? So the burial cost, which is about 6,000 to 7,000, I think, in London, I'm so sure. Then, if you got debt, as Hazrat Ali radiallahu anh, commenting on this ayat, wasiyatan yusa biha of dainin ghairi mudar. So you see, wasiyat and dain. But dain come first. In the ayat of Quran, wasiyah is coming first, then after that. But Ali radiallahu anh says that the Prophet ﷺ ordered payment of the debt before legacy. Debt is an obligation. Legacy is optional. So your debt comes before the wasiyah. So first you must pay your debt, and then you make the bequest, and then you make inheritance. There is a chronology there. Then you got inheritance. This is what some says. If you don't do it, then the prescription comes into play. Your heirs won't get it. If there is nobody to take it, it goes, and there will be problem. The state takes it. But if you make a residuary gift in your provision in your will, at least if when you got no heirs, it can go for a good cause, right? Next, I think it's finished now. Now, 5 main considerations on time, just on time, alhamdulillah. The law of inheritance in Islam is based on 5 main considerations. To break up the concentration of wealth in individuals and spread it out in society, number 1. To respect the property right of ownership of an individual earned through honest means. Number 3. To hammer in the consciousness of man the fact that man is not the absolute master of wealth. He produces it, he is trustee, and is not therefore authorized to pass it on to others as he likes. Because Allah, who is Al-Warith, one of the sifat of Allah is Al-Warith. He is the one who owns everything. So we got to observe, what we have is a trust from Allah. We got to manage it properly. The next one is to consolidate the family system, which is a social unit of Islamic society. When you look at the law of inheritance, it is based on 2 main things. One is called affinity, that is marriage. Number 2 is blood relationship. The closer the blood relationship, the more is a chance you will inherit. I have written an article on that as well. To give incentive to work and encourage economic activity as sanctioned by Islam. So this is the underpinning reason how the economic dynamism of law of inheritance is not about who gets what. There are a lot of philosophy behind it. I think it's finished now. Conclusion, failing to observe the Sharia rules leads to disobedience, while observing it leads to Jannah. However, one action that opens the gate of salvation is to ensure the deceased state is dissolved as per Islamic law. How to achieve it? Under UK law is your will, under the freedom of testation. If not, intestacy rules will apply. So, I just finished now. Jazakallah khair. I know it's a lot I have given, but inshallah, something will come. Jazakallah khair.
Jazakumullah khairan, Sheikh. We were supposed to begin the seminar sharp at 5 to have some question and answer at the end, but unfortunately the number of attendees were low, so we had this question and answer at the beginning. So I'm just quoting a hadith, the collections of hadiths including Sahih Muslim and Sahih Bukhari, reports that our beloved Prophet Muhammad said, it is not permissible for any Muslim who has something to will to say, to stay for 2 nights without having his last will and testament written and kept ready with him. So everybody, as Sheikh said, must look at it and start planning from now. So Alhamdulillah, we are on time, and we ask now Ustad Furi to make a dua for us, inshallah.
السلام عليكم ورحمة الله وبركاته. الحمد لله رب العالمين والصلاة والسلام على رسول الله صلى الله عليه وسلم. اللهم لك الحمد كما ينبغي لجلال وجهك وعظيم سلطانك. رضينا بالله ربا وبالإسلام دينا وبمحمد صلى الله عليه وسلم نبيا ورسولا. ربنا إننا آمنا بك فاغفر لنا ذنوبنا وكفر عنا سيئاتنا وتوفنا مع الأبرار. ربنا توفنا مسلمين والحقنا بالصالحين. اللهم أرنا الحق حقا وارزقنا اتباعه وأرنا الباطل باطلا وارزقنا اجتنابه. اللهم حبب إلينا الإيمان وزينه في قلوبنا وكره إلينا الكفر والفسوق والعصيان واجعلنا من الراشدين. اللهم أكرمنا ولا تهنا وأعطنا ولا تحرمنا وآثرنا ولا تؤثر علينا وأرضنا وارض عنا يا أرحم الراحمين. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار. ربنا هب لنا من أزواجنا وذرياتنا قرة أعين واجعلنا للمتقين إماما. اللهم اغفر لنا وارحمنا واغفر لآبائنا ولأمهاتنا ولأزواجنا ولجميع موتى المسلمين. اللهم إنك عفو تحب العفو فاعف عنا. اللهم إنا نسألك الجنة وما قرب إليها من قول وعمل ونعوذ بك من النار وما قرب إليها من قول وعمل. اللهم إنا نعوذ بك من خزي الدنيا ومن عذاب القبر ومن عذاب الآخرة. اللهم تقبل دعاءنا. اللهم توفنا مسلمين والحقنا بالصالحين. ربنا اجعلنا من عبادك الصالحين. اللهم تقبل دعاءنا. سبحانك اللهم وبحمدك نشهد أن لا إله إلا أنت نستغفرك ونتوب إليك. سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين برحمتك يا أرحم الراحمين.
I know you got a lot of questions. I'm leaving my card here. Whoever wants to take, and I won't reply immediately.